Appel versus Presley Companies concerns a couple who bought into a subdivision only to have the restrictive covenants governing construction change after they'd built their house. Daniel and Patricia Appel met with the Presley Company to discuss the purchase of a lot in a new subdivision Presley was developing. Presley informed them that the subdivision's restrictive covenants limited the ways the properties could be developed. Reassured that these restrictions would maintain the character of the neighborhood, the Appels purchased a lot and built a house on it. 2 years later, the subdivision's Architectural Control Committee amended the restrictive covenants so that they no longer applied to 9 of the undeveloped lots in the subdivision. This allowed subdevelopers to subdivide lots and build townhouses on them and to build in the arroyo, which had previously been off-limits to builders. Wolfe Company then bought one of these lots and replatted it into 4 lots for single-family homes. The Appels sued Presley, alleging breach of the restrictive covenants. They sought injunctions to prevent Wolfe from building on its lot unless it complied with the original restrictive covenants, and to prevent any construction in the arroyo. They argued that Presley had used the restrictive covenants as a sales tool, and that they'd relied on Presley's representations in purchasing their property and building their home. Presley argued that the subdivision's founding documents gave the Architectural Control Committee the right to make amendments or exceptions to any of the restrictive covenants, without consent of other property owners. The trial court found the language in these documents unambiguous and held that it clearly granted the committee the authority to remove individual lots from the covenants. The court granted Presley's summary judgment. The Appels appealed to the New Mexico Supreme Court.